And the court does not include upon the bench a judge of Nicaraguan nationality. Nicaragua availed itself of the right under Article 31, paragraph 2 of the statute to choose a judge ad hoc to sit in the case. It chose His Excellency Mr. Aoun Shawkat Al-Khassaw. Article 20 of the statute provides that, and I quote, every member of the court shall, before taking up his duties, make a solemn declaration in open court that he would exercise his powers impartially and conscientiously. Pursuant to Article 31, paragraph 6 of the statute, that same provision applies to judges ad hoc. Notwithstanding that Judge Al-Khassauni has been a judge ad hoc and made a solemn declaration in previous cases, Article 8, paragraph 3 of the Rules of Court provide that he must make a further solemn declaration in the present case. Before inviting Judge Al-Khassauni to make his solemn declaration, I shall first, in accordance with custom, say a few words about his career and qualifications. Judge Aoun Al-Khassauni, of Jordanian nationality, is well known to the court, having served as a judge from 2000 to 2011 and as vice president from 2006 to 2009. He also sat as judge ad hoc in the joint cases between Costa Rica and Nicaragua concerning maritime delimitation in the Caribbean Sea and the Pacific Ocean and land boundary in the northern part of Isla Portillo. Judge Al-Khassauni read history and law at Cambridge University and completed postgraduate studies in international law at the same university. He then pursued a distinguished career in the diplomatic service of his country, the Hashemite Kingdom of Jordan, including serving as the head of the legal department at the Ministry of Foreign Affairs, as ambassador, as advisor to the late King Hussein of Jordan, and advisor on international law with the rank of cabinet minister, and as chief of the royal court. He is well acquainted with the United Nations, having served as the representative of Jordan in the 6th Committee of the General Assembly for 2 decades, and as Jordan's alternate representative on the Security Council from 1981 to 1982. He was a member of the United Nations Subcommission on the Prevention of Discrimination and Protection of Minorities from 1984 to 1993. He was also a member of the International Law Commission from 1986 to 1999. He currently serves as a member of the Secretary General's High Panel on Access to Medicines. Judge Al-Khassauni has been chosen as arbitrator in several state-to-state and investor-state arbitration cases. He has also represented his country at numerous conferences and committees in the field of the progressive development of international law. After his departure from the court in 2011, Judge Al-Khassauni became Prime Minister of his country, a position he occupied until April 2012. He is an honorary fellow of Queen's College, Cambridge, and has lectured at prestigious universities around the world. He is currently a member as academic expert of Doughty Street Chambers in London. I shall now invite Judge Al-Khassauni to make his solemn declaration prescribed by the statute, and I request all those present to rise. Mr. Al-Khassauni.
I solemnly that I will perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously.
I thank you, Judge Khassauni. Please be seated. I take note of the solemn declaration made by Judge Al-Khassauni and declare him duly installed as Judge ad hoc in the present case. I shall now recall the principal steps of the procedure in the present case. On March 1, 2024, the Republic of Nicaragua filed in the registry of the court an application instituting proceedings against the Federal Republic of Germany for alleged violations by the letter of its obligations deriving from the Convention on the Prevention and punishment of the crime of genocide, to which I shall refer as the Genocide Convention, from the Geneva Conventions of 1949 and their additional protocols, as well as, and I quote, intransgressible principles of international humanitarian law and other norms of general international law in relation to the occupied Palestinian territory, particularly the Gaza Strip. In particular, Nicaragua argues that by providing political, financial, and military support to Israel, and by defunding the United Nations Relief and Works Agency for Palestinian Refugees in the Near East, Unrwa, I quote, Germany is facilitating the commission of genocide and in any case has failed in its obligations to do everything possible to prevent the commission of genocide, end of quote. To found the jurisdiction of the court, the applicant invokes the declarations by which both states accept the compulsory jurisdiction of the court and the compromissory clause contained in Article 9 of the Genocide Convention. The application also contained a request for the indication of provisional measures pursuant to Article 41 of the Statute of the Court and Articles 73, 74, and 75 of the Rules of Court. Nicaragua requests the court to indicate provisional measures as a matter of extreme urgency, pending the court's determination on the merits of the case with respect to Germany's alleged, and I quote, participation in the ongoing plausible genocide and serious breaches of international humanitarian law and other peremptory norms of general international law occurring in the Gaza Strip, end of quote. The registrar will now read out the passage from the request specifying the provisional measures which the government of Nicaragua is asking the court to indicate. You have the floor, Mr. Registrar.
Thank you, Mr. President. I quote, 1. Germany shall immediately suspend its aid to Israel, in particular its military assistance, including military equipment, insofar as this aid may be used in the violation of the Genocide Convention, international humanitarian law, or other peremptory norms of general international law, such as the Palestinian people's right to self-determination and to not be subject to a regime of apartheid. 2. Germany must immediately make every effort to ensure that weapons already delivered to Israel are not used to commit genocide, contribute to acts of genocide, or are used in such a way as to violate international humanitarian law. 3. Germany must immediately do everything possible to comply with its obligations under humanitarian law. 4. Germany must reverse its decision to suspend the funding of Unrwa as part of the compliance of its obligations to prevent genocide and acts of genocide and the violation of the humanitarian rights of the Palestinian people, which also includes the obligation to do everything possible to ensure that humanitarian aid reaches the Palestinian people, more particularly in Gaza. 5. Germany must cooperate to bring to an end the serious breaches of peremptory norms of international law by ceasing its support, including its supply of military equipment to Israel that may be used to commit serious crimes of international law, and that it continue the support of the Unrwa on which this organization has counted and based its activities. End of quote.
Je remercie.
I thank the registrar. Immediately after the application and the request for the indication of provisional measures were filed, the registrar transmitted an original copy thereof to the government of Germany. He also notified the Secretary General of the United Nations. According to Article 74, Paragraph 1 of the Rules of Court, a request for the indication of provisional measures shall have priority over all other cases. Paragraph 2 of the same article states that the court shall proceed to a decision on the request as a matter of urgency. This imperative must be, however, balanced with the need to fix the date of the oral proceedings in such a way as to afford the parties an opportunity of being represented at the hearings. The court had decided that these oral proceedings would be open on 8 April 2024. I would now like to welcome the delegations of the parties. I note the presence of the agents and Council of Nicaragua and the request for the indication of provisional measures. It will hear the single round of oral argument of Germany tomorrow, Tuesday, 9 April 2024 at 10 a.m. Both parties have a maximum allotted time of 2 hours each for their respective oral presentation. At today's sitting, Nicaragua may, if required, avail itself of a short extension beyond 12 noon in view of the time taken up by these introductory remarks. Before giving the floor to the agent of Nicaragua, I wish to draw the attention of the parties to practice direction 11, which states as follows, and I quote, "In the oral pleadings on requests for the indication of provisional measures, parties should limit themselves to what is relevant to the criteria for the indication of provisional measures as stipulated in the statute, rules, and jurisprudence of the court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose." End of quote.
The floor to the agent of Nicaragua, His Excellency, Mr. Carlos Arguello Gomez. You have the floor, sir.
Mr. President, members of the court, good morning. It is my honor to come before you representing Nicaragua in a case involving its rights and obligations, as well as those of the entire international community, and most importantly, those of the Palestinian people. The case before us involves momentous events affecting the life and well-being of hundreds of thousands of people, and even the destruction of an entire people. But in spite of the gravity of the situation, the facts in the law are very simply explained. Serious breaches of international humanitarian law and other peremptory norms of international law, including genocide, are taking place in Palestine. These breaches are being committed openly, have been witnessed on the ground by thousands of people, and have been viewed on public news services and social media by probably the majority of the population of the world. When a situation of this nature occurs or is in danger of occurring, the obligation for all states are clear. Not only states must not abet the situation by aiding or assisting the perpetrator, but they must use their best efforts to ensure respect for these fundamental norms and prevent their breaches. With respect to these obligations, there are no third states. All states are under the obligation to respect them. They are erga omnes obligations. Germany has violated these obligations imposed on all states. Mr. President, Nicaragua is not a newcomer to the court. On 9 April 1984, tomorrow it will be 40 years, Nicaragua filed an application against the United States for serious violations of international law against its rights and sovereignty. The present case is different, but it has a striking similarity. 40 years ago, in this month of April, during the hearings on provisional measures requested in that case, Nicaragua was asking, among other things, that the court order, and I quote, that the United States should immediately cease and desist from providing directly or indirectly any support, including training, arms, ammunition, supplies, assistance, finances, direction, or any other form of support to any nation, group, organization, movement, or individual engaged or planning to engage in military or paramilitary activities in or against Nicaragua. End of quote. In the present case, Nicaragua is also requesting the court to order that Germany should cease providing support to Israel in its campaign of destruction of the Palestinian people. But in the present case, Nicaragua is acting not only on its own behalf on the basis of the rights and obligations conferred by the peremptory norms invoked, but also on behalf of the Palestinian people that is being subjected to one of the most destructive military actions in modern history. Beyond its legal rights and obligations in bringing this case, the government and people of Nicaragua have a special sympathy for the plight of the Palestinian people. Nicaragua has not had to suffer the levels of inhuman treatment and destruction that has been the fate of Palestine for more than three-quarters of a century. Nonetheless, it has also been subject to intervention and military attacks for most of its existence and feels empathy for the Palestinian people. On the subject of empathy and sympathy, it is of note that Germany emphasizes that its assistance to Israel is a raison d'etat because of the historical treatment of the Jewish people during the Nazi regime. That is an understandable and laudable policy if it were addressed to the Jewish people. The Israeli state, and particularly its present government, should not be confused and equated with the Jewish people. The real friends of the Jewish people should emphasize the difference. The Jewish victims in the concentration camps during the Second World War will feel sympathy and empathize with the more than 30,000 civilians, including 25,000 mothers and children massacred so far in Palestine, and the 20,000 children orphaned, and 2 mothers being killed every hour. States like Germany that sympathize with what the state of Israel was meant to represent when it was created should be doing their best to put a stop to what is happening and not continue backing Israel in practice, even though they now, at least in public, perhaps forced by the enormous public outcry, make statements for peace 6 months after the start of the massacre, perhaps also in reaction to the present case before the court. With all due respect to this moral imperative of Germany that identifies defense of Israel as a raison d'etat, there is another less noble reality that perhaps is not known by the generality of the German people. There is also a lucrative quid pro quo involved. German companies involved in the military industry are directly profiting from the situation as they have seen their share prices rise since 7 October. And they have substantially increased the joint development contracts for weapons with their Israeli counterparts. Proudly and openly, on November 23, 2023, the Israeli Ministry of Defense announced that they had officially concluded an agreement to sell the Arrow 3 air defense system to Germany for an estimated $3.6 billion, describing it as the largest ever defense export of Israel. The Israeli defense minister further described the moment as, and I quote, an emotional moment to be here as the son and grandson of Holocaust survivors on German soil in Berlin to sign a defensive arms contracts. It's very important personally and diplomatically. This moment of history leans on our past and dictates our shared future. He called the sale a moving event for every Jew. End of quote. As has been reported many times, Israel is a technological hub, particularly in the weapons industry, and Israeli companies proudly advertise their products as battle-tested. Needless to say that for years the international community has been aware that the testing field is Palestine and its people, particularly Palestinians living in Gaza. Mr. President, the present case is different than that filed against Israel by South Africa, and in which Nicaragua is seeking to intervene as a party. The South Africa case only involves violations of the Genocide Convention by Israel. In the present case, Nicaragua is invoking the responsibility of Germany in connection with the genocide committed by Israel, and also the responsibility of Germany for the violations of its own obligations under the Genocide Convention and of the violations by Germany of its own obligations under international humanitarian law. The cases are thus different with respect to the norms being violated and with respect to the form of the violations. Germany is failing to honor its own obligation to prevent genocide or to ensure respect of international humanitarian law. The violations of international humanitarian law by Israel create obligations for Germany, as it does for all states of the international community, obligations for which Germany is responsible and which are being claimed in the present proceedings. Mr. President, the fact that the acts of one state generate independent obligations for third states is not an unusual legal situation. The first case of the present court, the Corfu Channel case, involved the laying of mines in Albanian waters that caused damages to the United Kingdom vessels. The court found no evidence that Albania itself had laid the mines or that it had colluded in the laying of the mines by a third party. But it was established to the satisfaction of the court, including by the report of experts appointed by the court, that, in a quote, laying of the minefield could not have been accomplished without the knowledge of the Albanian government, end of quote. And continue, and having that knowledge, open quotes again, the obligations incumbent upon the Albanian authorities consisted in not notifying, for the benefit of shipping in general, the existence of the minefield, end of quote. This ruling in the Corfu Channel case was taken up by the International Law Commission in the following manner, and I quote, a state may be required by its own international obligations to prevent certain conduct by another state, or at least to prevent the harm that would flow from such conduct. Thus, the basis of responsibility in the Corfu Channel case was Albania's failure to warn the UK of the presence of mines in Albanian waters which had been laid by a third state. Albania's responsibility was original and not derived from the wrongfulness of the conduct of any other state, end of quote. This judgment was one of the bases for the general rule contained in Article 16 of the Articles of Responsibility of States for Internationally Wrongful Acts, providing that a state which aids or assists another state in the commission of an internationally wrongful act by the latter is internationally responsible for doing so if that state does so with knowledge of the circumstances of the international wrongful act. It is pertinent to point out that the International Law Commission makes a special note of the situation when the responsibility arises from a serious breach of peremptory norms of general international law, which is the situation we are dealing with in the present case. In these circumstances, the International Law Commission comments that there is no need to mention the requirement of knowledge of the circumstances in Article 41, paragraph 2 of the Articles on Responsibility. As I quote, it is hardly conceivable that a state would not have notice of the commission of a serious breach by another state, end of quote. Mr. President, permit me to emphasize what the International Law Commission is pointing out. The violations of peremptory norms are facts that are evident in public knowledge. These are not facts that can only be established by a special authority and that can only be acted upon until they have been so established. They are facts that must be acted upon as soon as they have become known. The importance of this knowledge of the violations has been reiterated in other cases, and Professor Pillay will go briefly into some of them, since a short pleading on provisional measures is not the appropriate moment to go deeply into this question. Notwithstanding, a brief review of the reasons why Germany must have had knowledge and full awareness of what was happening and is happening in Palestine is useful. From the first days of the Israeli military actions in Gaza, it became evident that grave violations of international humanitarian law were being committed. Statements pointing this out were urgently made, among others, by the Secretary General of the United Nations on 9 October, by the President of the International Committee of the Red Cross on 11 October, and even at a political level with full participation of Germany in the statement by the High Representative of the European Union on 10 October, all of these on 2023. From that moment, even if the genocidal intent was not yet entirely evident, the grievous violations of international humanitarian law were evident. In practice, it was not even necessary to await these declarations in order to realize that, for example, dropping bombs of 1 ton in densely inhabited areas was a completely unjustifiable violation of the most basic humanitarian laws that had been recognized as such for many years, centuries in reality. If those statements just mentioned were not enough information to trigger the obligatory response by Germany, in your folders is a non-exhaustive list dating from 9 October until last Friday, 5 April, of 32 statements from hundreds of the most respected authorities, organizations, experts, legal scholars, and practitioners on questions of international humanitarian law, calling out that Israel was breaching or plausibly breaching the Genocide Convention and that it was breaching the most important norms of international humanitarian law. This ever-growing list includes the recent open letter of more than 600 legal experts, including 3 Supreme Court justices, calling the United Kingdom government to end weapons sales to Israel, as well as the resolution with a similar but universal call from the Human Rights Council of the 4th April, not surprisingly, with Germany's negative vote. With all this undeniable knowledge of the situation, Germany's reaction was to increase its military assistance to Israel. This complete support of Israel, even at the political level, was manifest when South Africa filed this application against Israel on 29 December 2023. The prompt reaction of Germany was to announce that they would intervene in favor of Israel. But apart from all these public statements and warnings of what was happening, the court, in its order of 26 January, considered that genocide was plausibly being committed against the Palestinian people. From that moment on, paraphrasing one of your members, the alarm was sounded and the indications of genocide activities were flashing red. With the alarm sounded, in fact, it was a final alarm, resounding amid a horizon of alarms from all quarters. There should have been no further possibility of ignoring the situation. And yet Germany continued and still continues to this day to supply weapons and military assistance in general to Israel. The norms of the Genocide Convention, which are part of customary international law, impose the obligation on third states to undertake to prevent genocide. This obligation arises from the moment that that state becomes aware that genocide might be committed. And there can be no question that Germany, as is evident from the preceding comments, was well aware and is well aware of at least the serious risk of genocide being committed, most certainly after your order of 26 January. The consequences of the violation of this obligation will be further addressed by Professor Pelé. In the present case, in addition to the obligations under the Genocide Convention, we are also invoking violations to other peremptory norms of public international law, particularly the norms of international humanitarian law of the Geneva Conventions, which are also norms of customary international law. Many of the violations of these norms are also part of the constitutive elements of the crime of genocide. For this reason, even if genocide were found to not have been committed, which Nicaragua does not accept, these violations of international humanitarian law stand alone and involve obligations for third states. A grievous example of this can be appreciated in the violations, among others, of Articles 55 and 56 of the Geneva Conventions and the duties of the occupying power of ensuring food and medical supplies for the occupied population. On this point, the court noted in its order of 28 March, and I quote, "The unprecedented levels of food insecurity experienced by Palestinians in the Gaza Strip over recent weeks, as well as the increasing level of epidemics." End of quote. As one of your members pointed out, these circumstances also reflect a plausible risk of a violation of relevant rights under the Genocide Convention. But even if it were found, quod non, that provoking this famine and catastrophic situation does not amount to genocide, it is in and by itself a clear violation of the Geneva Conventions. These norms also impose obligations erga omnes, which Germany, like all other states of the international community, is bound to respect, and therefore the violations of these norms in the binding aspects that they have on third parties can be claimed, are being claimed by Nicaragua against Germany as part of this case before the court. In view of the catastrophic situation of famine and epidemics in Gaza, the decision of Germany to suspend the funding of Unrwa and to maintain to this day the suspension of the funding of Unrwa's operations in Gaza is particularly telling of Germany's support of Israel. The question of the suspension of the funding will be reviewed by Dr. Mueller. At this point, some brief comments. Unrwa has been working in Palestine almost as long as the existence of Israel as a state. It has been providing the essential needs of the many refugees in the area. During this military campaign of Israel in Gaza, nearly 200 humanitarian workers, the majority of whom were part of the staff of Unrwa, have been killed. Israel accused about a dozen of the more than 12,000 workers of Unrwa with involvement in the events of 7 October. Immediately, and based on the sole say-so of the Israeli government, Germany suspended its funding of Unrwa. Incredibly, this occurred the day after your order of 26 January. What is striking in respect to this reaction of Germany is that on the say-so of Israel, they suspended assistance to Unrwa, but they have ignored the statements and the accusations of the most important world authorities that genocide and other violations of international humanitarian law were being perpetrated by Israel in Palestine, and continued their full assistance, including military assistance to Israel. Moreover, possibly realizing the absurdity of such a decision, Germany finally reversed its decision, except for the most shocking aspect, the suspension of funding for Unrwa operations in Gaza, precisely where it is most needed to limit the scale of the humanitarian disaster. Mr. President, up to this point, Germany has had the opportunity of studying our application and will have the opportunity of listening to our pleading today and responding tomorrow. Nicaragua has not had the opportunity to be informed of the position of Germany on the legal issues involved. The only reactions of which we have noticed are those mentioning our application. They amount to simply indicating that Germany rejects Nicaragua's claims, as well as other publications, other declarations justifying the backing of Israel's actions. From the public statements made by Germany, we could note two alleged justifications for the continued support of Israel: that Israel is not violating the Genocide Convention and that it has a right to defend itself. With respect to the first point, we already pointed out the full knowledge of Germany has of what is happening in Palestine and the legal consequences of this knowledge, not only of the plausible violations of the Genocide Convention, but also of the norms of international humanitarian law. This is not a question that can be or need be addressed during these pleadings, that are inevitably short since they are addressed basically to the issues involved in the request for provisional measures. In any case, Professor Pollet will have some further comments on this issue. With respect to the second point, the right of self-defense of Israel, which is also invoked by Germany for its continued assistance, some brief comments. The question of the right of Israel to defend itself is correct if it refers to the right to protect its people and not the right of self-defense contemplated in Article 51 of the United Nations Charter. But in the exercise of the right to protect its citizens, Israel, as occupying power, has assumed the duty to, and I quote from the regulations concerning the laws and customs of war on land, I quote, take all the measures in its power to restore and ensure as far as possible public order and safety while respecting, unless absolutely prevented, the laws in force in the country, end of quote. In practice, this implies that the police or general security powers the occupant has are similar to those of the state occupied. This right of protection is a right that frequently has to be exercised by states, even in difficult circumstances. But even in the most blatant situations of violence, the state has to respect the peremptory norms of international law. Mr. President, this is the bottom line. On whatever basis or definition a so-called right of self-defense is invoked, it can never serve to justify violations of the norms of the Genocide Convention or other norms of international humanitarian law. Surprisingly, Germany seems not to be able to differentiate between self-defense and genocide. Furthermore, Germany cannot invoke that Israel is in some state of necessity of its assistance for its defense and survival. In spite of its size and population, Israel is in the top 10% of the most militarily powerful countries in the world. Its per capita expense is more than 4 times larger than that of Germany. It is even higher than that of the United States. Its total yearly military expenditure, going back many years, is higher than that of its neighbors, Iran and Egypt, that have a population more than 10 times larger and immense territories in comparison with Israel. Mr. President, two considerations can also be briefly added on the question of the attacks that occurred on 7 October, which to our knowledge have not been taken into account by Germany. Firstly, the Palestinian people have the right to self-determination. That means that they have the right to take up arms against alien occupation and against racist regimes in the exercise of their right of self-determination, as enshrined in the Charter of the United Nations and the Declaration of Principles of International Law concerning friendly relations and cooperation among states in accordance with the Charter. This right must be exercised in line with the norms of international law as integrated in Article 1, Paragraph 4 of the 1977 General Protocol No. 1. Any violations of these norms that occurred on 7 October are not justified by the right of self-determination, but do not terminate this right of the Palestinian people, and even less the right to exist as a people. The second consideration that is sidelined is that the events on 7 October did not occur in a void, on the spur of the moment, without any provocation. This was pointed out a few days after the events of October 7 by the Secretary General of the United Nations speaking before the Security Council. He stated, and I quote, "It is important to also recognize the attack by Hamas did not happen in a vacuum. The Palestinian people have been subjected to 56 years of suffocating occupation," end of quote. If it were necessary to confirm the truth of the statement of the Secretary General, it is not necessary to make an interminable list of the suffering of the Palestinian people since the Nakba in 1948. If we could simply recall the statement that the Secretary General himself had made 3 years earlier on 21 May 2021 in an address to the United Nations General Assembly. He said, and I quote, "If there is a hell on earth, it is the lives of children in Gaza today," end of quote. Today was 3 years ago, before 7 October. Mr. President, members of the court, if the actions of Israel continue unrestrained as they have since its birth as a state, and they continue to receive the indiscriminate support of states like Germany, then a new generation of Palestinians will rise up again in the near future. And we will hear a future Secretary General commenting, "This did not happen in a vacuum." The case before the court is an opportunity to break this vicious cycle. Without support of states like Germany, Israel will not feel it can act with total impunity. Nicaragua is hopeful that states, particularly with the history of Germany, will heed the decisions of this court. Thank you, Mr. President, members of the court. With this, I end my presentation. And may I please ask you, Mr. President, to give the floor to Dr. Daniel Mueller. Thank you.
I thank the agent of Nicaragua for his statement. I now invite Mr. Daniel Miller to take the floor. You have the floor, sir.
Thank you, Mr. President. Mr. President, members of the court, my task this morning is to set out some of the facts underlying the dispute between Nicaragua and the Federal Republic brought before the court. I shall, of course, concentrate on those facts that are relevant for the request for provisional measures. Nicaragua has already explained the factual background in its application. Unfortunately, since then, the situation has evolved further, and in light of that, provisional measures are becoming increasingly more urgent and necessary. Mr. President, members of the court, you are already acquainted with the devastating situation in Gaza and the imminent risk to which the Palestinian people, children, women and men in Gaza, but also in other parts of the occupied Palestinian territory, is currently exposed. 10 days ago, you qualified the living conditions imposed on Palestinians as catastrophic, and the most recent developments in Gaza as exceptionally grave. The court knows and has acknowledged that there was an imminent risk of irreparable harm to the rights of the Palestinians in Gaza to be protected from acts of genocide and related prohibited acts identified in Article 3 of the Genocide Convention. And you concluded twice that the situation was such as to justify provisional measures aimed at protecting the right of the Palestinian people in Gaza as a people. In fact, measures aimed at ensuring their sheer existence and survival as a group. You also considered that the catastrophic humanitarian situation in the Gaza Strip is at serious risk of deteriorating. Since the end of January, the situation has indeed worsened and deteriorated. Already on 16th of February, the court endorsed the grave concerns expressed by the United Nations Secretary General before the General Assembly and noted that, and I quote, "The most recent developments in the Gaza Strip and in Rafah in particular would exponentially increase what is already a humanitarian nightmare with untold regional consequences." Yet, what was then a desperate call for reason, action, and change has turned into blatant and brutal reality. The situation has increased the nightmare. The nightmare is increasing every single day. The Republic of Nicaragua draws your attention to the escalation of the situation in Gaza in its application and its request for provisional measures. And again, in the letter of its agent dated 7th of March. The Republic of South Africa reiterated it again in its request of 6 March. In your order of 28 March, you also acknowledged that the catastrophic humanitarian situation in the Gaza Strip has deteriorated even further. Mr. President, members of the court, this is still the reality in Gaza. Only 2 weeks ago, the United Nations Secretary General visiting Egypt and the border with Gaza made the horrifying comment that, and I quote, "Looking at Gaza, it almost appears that the 4 horsemen of war, famine, conquest, and death are galloping across it." And he continued, "Nothing justifies the abhorrent October 7 Hamas attacks and hostage-taking in Israel, but nothing justifies the collective punishment of the Palestinian people." End of quote. The world is aware of all of that, and the world cannot turn its eyes away. The risk, if this term is still appropriate, of irreparable harm to the rights of the Palestinian people in Gaza to be protected from acts of genocide and to live in dignity is very real indeed, imminent and grave. As recently as last Friday, the UNOCHA director reported to the Security Council on the unconscionable brutality of the conflict and confirmed again the tragic reality that there is no protection of civilians in Gaza. While the world is witnessing the destruction of Gaza and its life, the situation in the remainder of the occupied Palestinian territory has been deteriorating too. Last February, the Minister of Foreign Affairs of Palestine described at this bar the suffering of the Palestinian people throughout the occupied Palestinian territory, subjected to the colonization of their territory, to the racist violence that enables it, to the denying of their fundamental rights, to the most inhuman segregation and apartheid, to the negation of their very existence. Day by day, raids, airstrikes, violence against and illegal detention of Palestinians in the West Bank are intensifying. Members of the court, the Federal Republic was and is aware of the situation and in any event could not have ignored it. Despite the very many warnings, alarming reports and messages of the United Nations Secretary General, United Nations Special Rapporteurs, the International Red Cross, and even the European Union's High Representative, Germany continues to assure and implement full support to Israel for its war against Gaza and its population. Addressing the Bundestag on 12th of October 2023, the German Chancellor stated, and I quote, At this moment, there's only one place for Germany, the place at the side of Israel. That is what we mean when we say that Israel's security is a German raison d'etat. Our own history, our responsibility arising from the Holocaust, makes it our perpetual duty to stand up for the existence and security of the State of Israel. This responsibility guides us. The Minister for Foreign Affairs said the day before, and I quote her, "Israel's security is a German raison d'etat. With this understanding, I have offered Israel all our support in every area." This was also confirmed by the spokespersons of the federal government and the Federal Foreign Office, who both underlined that solidarity with Israel is paramount. Germany's support to Israel in every area, and in particular in the form of supplying weapons of war, was immediate. On 12th of October 2023, the Federal Minister for Defense confirmed in Brussels that Germany had allowed Israel's air forces to use 2 Heron military drones for what he called Israel's defense battle. The widespread and indiscriminate destruction caused by unmanned aerial vehicles like these drones to civilians, to civilian infrastructure, to houses and homes, and to humanitarian aid workers had been widely reported. In early November, a representative of the Federal Ministry of Economy and Climate Protection confirmed that, due to the situation, the German government processed and decided on applications for the export of military equipment to Israel as a matter of priority. The German government had authorized for the year 2023 exports of military equipment and war weapons in the amount of more than 326 million euros. Although Germany was even before October 23, Israel's second most important supplier of military equipment, this figure shows that export licenses granted by the Federal Republic are more than 10 times as important as for the year 2022. Most of these licenses were granted in the second half of 2023, after the invasion of Gaza by Israel and the start of its war in the territory and against its population. Indeed, according to the official figures of the German government, until 30 June 2023, only licenses in the volume of 38 million euros had been granted. In other words, export licenses for military equipment worth almost 300 million euros had been delivered by German authorities as a matter of priority within and against the background of the specific situation of Israel's war in Gaza and against its population. This includes export licenses for weapons of war in the value of 20 million euros, such as 3,000 anti-tank weapons, which according to one manufacturer in Germany are a complete toolbox of shoulder-launched infantry weapons used against tanks, but also vehicles, structures and buildings, and persons. 500,000 rounds of machine gun ammunition, 44 propellant charges, a key component in artillery ammunition, and 239 ignition charges. These are weapons built to and aimed at destroying and killing. Or to quote from Germany's own definition, objects and substances capable of causing destruction or damage to persons or property, and of serving as a means of using force in armed conflicts between states. In early 2024, the German federal government continued to provide export licenses for military equipment and weapons of war. According to the data submitted by the government to the members of the Bundestag, these licenses concerned military equipment of a value of more than 9 million euros. And despite requests made by members of the Bundestag concerning more recent data, at the best of our knowledge, no further information has been made available by the federal government since the introduction of the present proceedings. Mr. President, although those figures are telling, they do not reflect the full picture of the military support provided by Germany and the German industry to Israel's war in Gaza. These figures do not include export of equipment that does not fall under the export license requirements. They do also not include supply of military equipment directly by Germany to Israel. And the German news magazine Der Spiegel revealed information about plans of the German government to deliver tank ammunition from the stocks of the German armed forces. Moreover, due to the very dense and intense cooperation between Germany and Israel, also in terms of military equipment and exports, a great part of the military machinery and equipment of Israel is, at least partially, from Germany and depends on supplies, motors, engines, and spare parts from Germany too. Israel saw 6 corvette warships built by the German group ThyssenKrupp and sold with the support of the German government in 2015 have been used since October against Gaza and its people. And German manufacturer Mercedes is under contract with Israel's armed forces, in particular for the delivery of tank carriers, and has speeded up its operation amidst the war. Of course, Germany could not and did not ignore the situation in Gaza, largely documented by the press, official reports, and statements. Germany could not and did not ignore the likelihood that its support, the military equipment and the weapons of war, would be used by Israel to bomb and kill thousands of Palestinian children, women, and men. These questions were raised time and again, and this from the very beginning of the large-scale invasion of Gaza. Already on 11th of October, the spokesperson of the Federal Foreign Office was asked very directly whether the military actions of Israel were in conformity with international humanitarian law. He eluded the question and replied that, and I quote, "Israel has the right under international law to defend itself against the current attack, the terrorist attack by Hamas. We support this right and we stand by Israel's side," end of quote. And he added simply in passing that, and I quote again, "Of course, even in this absolutely exceptional situation, the protection of the civilian population is a requirement of international humanitarian law," end of quote. On 8 November, the federal government was specifically asked whether, to its knowledge, Israel is fully complying with the relevant norms of international law, international humanitarian law, and refugee law in its current military operations in the Gaza Strip. In its response, the government confirmed that under the relevant legal framework, export licenses must be denied if there is a clear risk that the military technology or equipment to be exported might be used to commit serious violations of international humanitarian law. And despite the numerous reports on the concrete situation in Gaza, which Germany could not have ignored, the government representative continued, and I quote, "Israel assures the German government that it is taking precautions to ensure compliance with the requirements of international law. The German government currently sees no reason to doubt this." Against the continuing reports on the catastrophic situation in Gaza, the German authorities seem to have finally started to doubt Israel's assurances. On 25th January 2024, the federal foreign minister declared that, and I quote, "Notwithstanding the right to self-defense, there are rules, and the international humanitarian law also applies in the fight against terrorists. Israel needs to respect these rules, just like all other states in the world, even if a difficult environment in which even in the difficult environment in which Hamas is breaking them all and using people as human shields. However, irrespective of these assertions, and indeed the very clear risk that grave violations of humanitarian law and international law are committed in Gaza, recognized by your court, Germany has not suspended its military support. The Federal Republic, together with other European Union member states, again expressed its concerns about the humanitarian situation in Gaza and the suffering of the hostages, as well as the Israeli government's plans for a possible ground operation in Rafah on 19 February 2024. It recalled in this context the importance of ensuring the protection of all civilians at all times in line with international humanitarian law, and to respect the 26 January order of the International Court of Justice, which is legally binding. Yet again, no suspension of its military support for Israel. Germany did also not move after the Court of Appeal of The Hague concluded that there were many indications that Israel has violated the humanitarian laws of war and ordered the Kingdom of the Netherlands to cease all actual export and transit of F-35 parts, which final destination Israel. The Canadian Parliament recalled that, and I quote, Israel must respect international humanitarian law, and the price of defeating Hamas cannot be the continuous suffering of all Palestinian civilians, end of quote. The Canadian government stopped approving exports of military equipment like other states before. Germany did not. Members of the court, if Germany might not have doubted the assurances of Israel in October 2023, as it claimed then, this is simply not tenable anymore. On 24th March, the federal foreign minister referred to the hell of Gaza and the dire situation of people starving to death. She also underlined that military action has its limits in international humanitarian law. And during her visit in Tel Aviv, Ms. Baerbock announced that Germany will send a delegation to Israel to discuss questions of international humanitarian law because, and I quote, as a signature of the Geneva Convention, Germany is obliged to remind all parties of their duty to abide by international humanitarian law, end of quote. And still yesterday, it was reported that a group of 600 German civil servants was calling on the government to cease armed deliveries to the Israeli government with immediate effect, exactly because, and I quote, Israel is committing crimes in Gaza that are in clear contradiction to international law and thus to the Constitution, which we are bound to as federal civil servants and public employees. Nevertheless, Germany still has not taken the decision to suspend its military support and the export of military equipment to Israel. Rather, in a recent response to a series of questions asked by members of the Bundestag, the government reiterated its position that export licenses will be considered on a case-by-case basis and in light of specific circumstances. Members of the court, to put it simple, highest German officials have recognized that the situation in Gaza raises doubts about the respect of elementary rules of international law, and that these questions need to be addressed. Yet, while we speak, the export of German weapons and military equipment to Israel, likely to be used for committing these grave violations of international law, is continuing. The German government has also not made any declaration concerning the stop of its military support to Israel after the United Nations Security Council demanded an immediate ceasefire. Contrary to the Canadian or the Dutch governments, it has not decided to stop nor suspend its supplies of arms to the Israeli government, nor has it resumed its funding of Unrwa's humanitarian operations in Gaza. The fact that Germany is engaged in facilitating or improving humanitarian aid in Gaza and for its suffering people does not change the picture. It is indeed a pathetic excuse to the Palestinian children, women and men in Gaza to provide humanitarian aid, including through airdrops on the one hand, and to furnish the weapons and military equipment that are used to kill and annihilate them, and to kill also humanitarian aid workers, as most recently evidenced by the missile attack against vehicles and workers of World Central Kitchen. On the other hand, humanitarian aid in itself cannot keep the hope for peace alive as demanded by Ms. Baerbock, in particular if the safety of those delivering this aid is not guaranteed and their work hampered. To take the words of the European Union High Representative Josep Borrell, and I quote, "If you believe that too many people are being killed, maybe you should provide less arms in order to prevent so many people from being killed. It is a little bit contradictory to continue saying that there are too many people being killed. Too many people being killed, please take care of people. Please do not kill so many. Stop saying please and do something." End of quote. Yet Germany continues to say please without doing what it is supposed to do. In fact, required under international law to do, stopping its support, in particular its military support, and ensuring compliance by Israel with international humanitarian law. Mr. President, this brings me to the last point I want to quickly touch upon. Germany did not only not do something about its military supply and aid, it also decided to suspend its contribution to Unrwa that is supposed to take care of people in Gaza. There is no question that Germany fully appreciates the importance of Unrwa for the Palestinian people in Gaza and elsewhere in the occupied Palestinian territory. Before 7th of October 2023, Germany was by far one of the most important donors to the agency, its second most important contributor. After having suspended its development aid to the occupied Palestinian territory in October 23, the Federal Ministry for Economic Cooperation and Development released funds initially earmarked for Unrwa's operation in Gaza on 7th of October 2023. The Federal Minister recognized then that, and I quote, "Unrwa is the most important partner for providing assistance to the people in the Gaza Strip," end of quote. On 13th December 2023, the German authorities confirmed that the review of allegations of misuse was completed and that the safeguards are robust and that no indications of the misuse of funding have been found. They further explained and recognized the central role of Unrwa for the Palestinian people in Gaza, and I quote, "The first focus of the review was activities that ensure the provision of basic services for the people, especially for particular vulnerable groups. This is why the projects run by the Unrwa, which provide life-saving services, were first reviewed and approved, followed by projects under Germany's transitional development assistance, which are making a direct contribution towards services for civilians in the current crisis." End of quote. The central and vital role of the Agency for the Palestinian People and its sheer existence, fully recognized and endorsed by the Federal Republic, had also been recalled by the United Nations Secretary General. Unrwa was and remains the backbone of the humanitarian distribution in Gaza. No other organization has a meaningful presence inside Gaza, and there is no other organization that would be able now to replace Unrwa. This remains the case today, as recently recalled on last Friday in the Security Council and in the Human Rights Council. Nevertheless, and in full knowledge of the consequences, Germany suspended its funding of UNRWA's operation in January 2024 amidst still unsupported accusations against the agency, and this despite immediate action taken by UNRWA to address these accusations and Germany's previous own assessment of the robustness of the control mechanisms. The suspension of funding deprived the agency of $450 million with no capacity to absorb this financial shock, in particular in the pressing situation of war raging in Gaza. UNRWA's Commissioner General urged, and I quote, countries who have suspended their funding to reconsider their decisions before UNRWA is forced to suspend its humanitarian response. The life of people in Gaza depend on this support, and so does regional stability, end of quote. Germany acknowledged, while still authorizing supply of military equipment, that the humanitarian situation in Gaza is catastrophic and the situation of the people there is becoming more desperate with each passing day. Yet it has not, to this day, resumed the funding of the operations of UNRWA in Gaza, which were needed more than ever. Nicaragua does of course welcome the decision of the German authorities to provide new funds to UNRWA's operation in Jordan, Lebanon, Syria, and the West Bank. But still, the much needed support for the agency's central and life-saving operations in Gaza remains suspended. This unjustified decision contributes to the suffering in Gaza, where children, women, and men are starving, a situation created by the attempts to ensure the defunding of the agency. According to UNRWA, it is lacking 35% of the forecasted income for 2024. For good reason, this court has considered on 28th of March 2024 that in view of the worsening conditions of life faced by Palestinians in Gaza, in particular the spread of famine and starvation, it is necessary to, and I quote the court, take all necessary and effective measures to ensure without delay, in full cooperation with the United Nations, the unhindered provision at scale by all concerned of urgently needed basic services and humanitarian assistance. Mr. President, members of the court, I thank you for your attention, and Mr. President, may I ask you to give the floor to Professor Alain Pellet.
I thank Mr. Miller for his statement. J'appelle maintenant.
I now invite Professor Alain Pellet to take the floor. You have the floor, sir. Mr. President, members of the court, Germany is not legally responsible for the inferno that has engulfed Gaza, or rather, it is only responsible through its own breaches of its own international obligations linked to this horrific situation. And it is responsible to the extent that these breaches have made possible or facilitated the grave violations of general international legal norms directed at the Palestinian people, not only within the Gaza Strip, but also in the occupied territories and in Israel itself. It is this that justifies both Nicaragua's application addressed at Germany and also the request for provisional measures which are the reason for the hearing today. I don't think I need to dwell on the question of Nicaragua's jus standi. As you recalled so well in your order of the 26th of January of this year, in referring to the Gambia versus Myanmar case, and I quote, all the states parties to the convention, to the Genocide Convention, have a common interest to ensure the prevention, suppression, and punishment of genocide. These are obligations that are erga omnes partis, and each state party has an interest in compliance with them, including through the institution of proceedings before the court. Mutatis mutandis, the same applies in this case. Germany and Nicaragua are parties to the Genocide Convention, under which they both have obligations and rights that they are entitled to invoke before you. However, and our agent stressed this, Nicaragua's requests are not limited to breaches of the 1948 Convention. They also concern breaches by Germany of its own obligations under the 4 Geneva Conventions of 1949, including the 4th one, concerning the protection of civilian persons in time of war, and the 1966 protocols. And our application also refers to other breaches on the part of Germany concerning other relevant treaties that preserve and protect human rights or concern humanitarian international law. All of these conventions set out obligations that are erga omnes partis. Every state party has a legal interest to ensure compliance therewith, including through proceedings brought before this court. As you underlined in your opinion on the wall, and I quote, all the states parties to the Geneva Convention relative to the protection of civilian persons in time of war of the 12th of August 1949 are under an obligation while respecting the United Nations Charter and international law to ensure compliance by Israel with international humanitarian law as embodied in that convention, end of quotation. Furthermore, as a member of the International Community of States, Nicaragua asks the court to find that Germany has seriously violated its obligations under the peremptory norms of general international law in these same areas and sanction it for such breaches, whether we're talking about breaches of prevention and punishment of crimes of genocide or apartheid, breaches of fundamental principles in the area of human rights or humanitarian law, or the right to seek reparations in the interests of the Palestinian people. Here again, the court's findings in Gambia versus Myanmar, recalled in your order of the 26th of January, should fully apply. As you indicated in your advisory opinion on the legality of the threat or use of nuclear weapons, so as I was saying, legality of the threat or use of nuclear weapons, and recalled in that on the wall, and I quote, a great many rules of humanitarian law applicable in armed conflict are so fundamental to the respect of the human person and elementary considerations of humanity that they are to be observed by all states, whether or not they have ratified the conventions that contain them, because they constitute intransgressible principles of international customary law. In the court's view, these rules incorporate obligations which are essentially of an erga omnes character. End of quotation. I note that in any case, at this stage, it is for you solely to decide on your prima facie jurisdiction, without there being any need for you to definitively state, and I quote, to satisfy yourself in a definitive manner that you have jurisdiction as regards the merits of the case. So, members of the court, today, you are not being invited to exercise your jurisdiction on the merits. At this stage, it is for you just to indicate the urgent measures, and I quote once again, likely to preserve by such measures the rights which you may subsequently adjudge to Nicaragua. The court's jurisprudence is based on a distinction between two different concepts. On the one hand, the existence of the court's jurisdiction, and on the other, the exercise of its jurisdiction where that jurisdiction is established. The fact that in this instance, the court's jurisdiction is established prima facie in order to rule on the application is without any shadow of a doubt. Your recent jurisprudence amply confirms this, and that is enough also to grant you jurisdiction to indicate the provisional measures sought. It is also enough to rule out the objection that Germany doubtless will rely on tomorrow based on the monetary gold principle. Even although, par excellence, this is a question that is nothing to do with the existence of jurisdiction, of which there is no doubt, but of the exercise thereof. Even if the dramatic circumstances in the case before you today in no way lend themselves to any doctrinal soul-searching, allow me, Mr. President, to say that I have never understood the value of this so-called principle, even although it was articulated in a case that had quite exceptional features. The court on several occasions has stated that it was attached to it at the expense of intellectual acrobatics that strike me at times as being extreme. If it is just a question of saying that the court's jurisdiction is based on consent, Article 59, together with the possibilities that the statutes offer states when it comes to intervening, whether they are parties or not, is sufficient for the purpose, to my mind. As you have recalled, citing judgment number 11 of the Permanent Court, and I quote, "The object of Article 59 is to prevent legal principles accepted by the court in a particular case from being binding also upon other states or in other disputes." And it is clear from the latter provision that the principles and rules of international law found by the court to be applicable in the relations between Germany and Nicaragua, and the indications given by the court as to their application in practice cannot be relied on by the parties against any other state. End of quotation. But let's say that the monetary gold principles is something other than a short-term judicial invention, and if not superfluous, at least clearly without relevance in this case. And let's take it seriously. There are at least two arguments, members of the court, that should lead you to dismiss it. Firstly, as I just said, at the stage of provisional measures, this question doesn't arise. At this stage, you're not asked to rule on the merits of the legal or factual situation resulting from the violation of the applicable legal principles. What is more, and in any case, it is not enough for the future judgment, and I quote, the fact that it might affect the legal interests of a state which is not a party to the case, for the principle of monetary gold, if such a principle exists, for it to apply. In the very terms used in the 1954 judgment, this is only the case if the vital issue to be settled concerns the international responsibility of a third state. That was the case in the very peculiar instance in 1954 when Italy expressly requested of the court that it decide that the governments of the respondent states should give to it the share of monetary gold normally assigned to Albania. But that is not true of the case before us today, in which there is no I repeat, no request that is related to any right of a third state. The court's position in monetary gold cannot be used to prevent the court from ruling on an application involving a country that agrees to appear before it. Mr. President, it is clearly the application that in each case makes it possible to determine the vital issue to be settled. In this case, the reading of the application submitted by Nicaragua on the 1st of March allows for no doubts to prevail as to its purpose. It is not to find out whether Israel has breached its international obligations, but whether Germany has breached its obligations. In your order of the 26th of January, you considered that the court is not called upon to determine definitively whether the rights which South Africa wishes to see protected exist. The same applies in this case. At this stage here, the court is invited to decide whether the rights complained by Nicaragua and for which it is seeking protection are plausible. Here again, I think there is no need to waste your precious time, nor to squander the time allotted to us to go into exaggerated detail here. In your wisdom, you are increasingly drastic in limiting the time allowed for the parties to present their pleadings. In the same order, the 26th of January, you stated, and I quote you, that the facts and circumstances mentioned that you noted at the time are sufficient to conclude that at least some of the rights claimed by South Africa and for which it is seeking protection are plausible. This is the case with respect to the right of the Palestinians in Gaza to be protected from acts of genocide and related prohibited acts identified in Article 3 of the Convention on Genocide, and the right of South Africa to seek Israel's compliance with the latter's obligations under the Convention. End of quotation. As we can see from the facts set out by Daniel Müller, this is all the more plausible, not to say proven, today. You confirmed in your order of the 28th of March that since that time, the catastrophic living conditions of the Palestinians in the Gaza Strip have deteriorated further, and this since the 26th of January. And further quotation, the current situation before the court entails a further risk of irreparable prejudice to the plausible rights of the Palestinian people of Gaza. The measures sought by Nicaragua concern protection of its right to see Germany comply with its obligations under the Genocide Convention, and the protection of the concomitant rights of the Palestinian people, which are directly affected by Germany's conduct. It is a right, and it is also a conventional obligation. Without the slightest hesitation, the same reasoning applies when we turn to the violation of major treaties that protect human rights or that codify international humanitarian law and that I enumerated earlier on. We see this in the horrors of the hell of Gaza that you referred to yourselves, in the abuses inflicted by Israeli settlers in the occupied Palestinian territory, the victims of which are increasingly the Palestinians of the West Bank. Once again, Mr. President, I don't believe there's any need to be a soothsayer in order to anticipate the protests from the German respondent. Yes, the humanitarian situation in Gaza is worrying, and when I say we, it's Germany I'm talking about, we're worried about it, and we are making this known, but it's nothing to do with us. We're not committing any of the genocidal acts that have been enumerated in Article 2 of the 1948 Convention, nor do we intend to destroy in whole or in part a national, ethnic, racial, or religious group, whatever the definition that is given to it, as embodied by the people of Palestine. And I have no doubts that this Pontius Pilate-like stance, with an equally clear conscience, will be repeated when it comes to the violation of human rights and humanitarian law. There are no German soldiers in Gaza, nor in the occupied Palestinian territory. It has to be understood, and we can but approve that Israel has a right to defend itself, unless their conscience gets the better of them, and our learned friends show restraint on this, given the monstrously disproportionate retaliation to the Hamas attack of the 7th of October. And as in any case, nothing at all can justify the systematic targeting of hospitals, schools, and distribution of food still being carried out by the rare NGOs still managing to survive in Gaza. In any case, there seems little doubt that Germany tomorrow will say, "It wasn't me, Mr. President, it wasn't me." If that is the case, then it's clearly in the wrong proceedings. The matter before us here has been set out very clearly in paragraph 3 of the application and is repeated in the conclusions of the application. Nicaragua, what is it that it reproaches Germany of? It is not, and there's a reservation there that I'll come back to in a moment, it's not committing genocide in the Gaza Strip or in Palestine. It is that it has failed and continues to fail to fulfill its own obligations to prevent genocide being committed and to punish those committing genocide or involved in any of the acts set out in Articles 2 and 3 of the Convention. It is not accusing it of breaching obligations on parties at war, because Germany is not involved in the Israel-Palestinian conflict, nor is it anything to do with obligations specifically concerning occupying powers. Germany is not an occupying power. Nicaragua accuses it of not complying with its own obligations as Germany under international humanitarian law that it must comply with in any circumstances, and that includes its obligation to prosecute, try, and punish persons responsible for or accused of serious crimes under international law, whether it is genocide, war crimes, or apartheid. Far from doing so, Germany is going ahead with business as usual, or rather, as Daniel Müller explained, business better than usual. Arms sales have not ceased. They have increased significantly. Nor does Nicaragua accuse Germany of pursuing an apartheid policy against the Palestinian people or of denying its right to self-determination. What it accuses it of is providing aid and assistance to the preservation of systematic racial discrimination and the apartheid regime that the Palestinian people is a victim of, and of failing to fulfill its obligation to cooperate in achieving its right to self-determination, and this by providing Israel with assistance particularly military, that is being used and can be used to prevent the exercise of self-determination. And it's indeed Germany, not any other state, not Israel, that Nicaragua accuses of suspending, of cutting off funding to Unrwa for its activities in Gaza, preventing it from carrying out a vital, irreplaceable humanitarian role in the enclave at a time when that role is increasingly indispensable. In this way, facilitating Israeli abuses and aggravating famine, the lack of water and medical care, and aggravating further the humanitarian catastrophe. The same can be said of the request to indicate provisional measures, and our agent in a few moments will read out the final version. Within the inherent limits of the court's jurisdiction, they all concern and only concern Germany. Whether we are talking about Germany having immediately to suspend its aid to Israel, in particularly its military assistance, insofar as this aid may be used in the violation of the Genocide Convention or other peremptory norms of general international law. Germany must immediately make every effort to ensure that weapons already delivered to Israel are not used to commit genocide or are used in such a way as to violate international humanitarian law. Or, again, Germany must reverse its decision to suspend the funding of Unrwa in Gaza as part of the compliance of its obligations to prevent genocide and serious violations of international humanitarian law. These are specific and precise requirements that concern only Germany and that are all capable of immediately bringing relief to the suffering of the Palestinians and the violations of the most fundamental principles of humanitarian law, and also to mitigate the genocidal pressure of which the Palestinians are victim. Mr. President, I don't want to go into detail of Nicaragua's complaints addressed to Germany, but I would like to give a few examples of their autonomous existence as compared to those that might be addressed to Israel if the latter were to accept the jurisdiction of the court, aside from the single exception to Article 8 of the Genocide Convention. But let's begin with this. I've said that except for one aspect, and it's an important one, Nicaragua is not accusing Germany of committing genocide against the Palestinian people in Gaza or elsewhere. What it is saying it is responsible of in the first instance is a failure to fulfill its obligations to prevent and punish the crime of genocide, an obligation that weighs on all parties to the 1948 Convention. This can be seen from the full title of the convention, its very first article, in which, and I quote that article, the contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law, which they undertake to prevent and punish. They undertake to prevent and to punish. As the court has underscored with considerable firmness in the very first contentious case on genocide that was brought before the court, and I quote, the obligation on each contracting party, state, on each contracting state to prevent genocide is both normative and compelling. Furthermore, Germany is well aware of this. It relied on this very duty in intervening in the case of genocide against the Rohingya. And it was even more explicit in a statement made by the Federal Ministry of Foreign Affairs on the 17th of November 2023, and I quote it in English.
Feels it has a special responsibility to contribute to the fight against and the prevention and investigation of any potential genocide, and to send a message that states will be held accountable for all acts of genocide. Genocide concerns us all, wherever in the world it occurs. Well, I have never known how to use this. It was the first time I tried to use my phone.
It is this obligation that Germany has not respected. It is this breach which you will be called on to appraise when you are looking at the merits of the case. And I would also like to note that this is an obligation of behavior and not result, which is what differentiates us from the idea of not committing genocide, as the court has already noted in its judgment of 2007. The result, and this is fundamental, is that the obligation of states parties is to employ all means reasonably available to them so as to prevent genocide as far as possible. A state does not incur responsibility simply because the desired result is not achieved. Responsibility is, however, incurred if the state manifestly failed to take all measures to prevent genocide which were within its power and which might have contributed to preventing the genocide, end quote. I know very well, Mr. President, that a state can be held responsible for breaching the obligation to prevent genocide only if genocide was actually committed. However, as the court has asserted also, this obviously does not mean that the obligation to prevent genocide only comes into being when the perpetration of genocide commences. That would be absurd, since the whole point of the obligation is to prevent or attempt to prevent the occurrence of the act. This duty of prevention of the act arises at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. From that moment onwards, if the state has available to it means likely to have a deterrent effect on those suspected of preparing genocide, or reasonably suspected of harboring specific intent, dolus specialis, it is under a duty to make such use of these means as the circumstances permit, end quote. There is no doubt, Mr. President, that where we are today, for any observer, for any state of good faith, the threshold of awareness has largely been crossed. The possibility of a genocide or of an apartheid, the truth of the serious breaches of the most fundamental rules of international humanitarian law have amply been overstepped. Incidentally, at the stage of provisional measures, it is enough for you to determine first the plausibility that a genocide could be committed against the Palestinian people, and also that, or on the other hand, that Germany has not complied with its obligations to employ all means reasonably available to them so as to prevent genocide so far as possible, and the breach of numerous other intransgressible principles which are at stake. You have adjudicated on the plausibility of a genocide in your orders of 26 January and 28 March of this year. Unfortunately, the situation has only worsened since then, as Daniel Mueller has already shown. I would like to add that the acts, which in all likelihood come from the definition of genocide, are committed elsewhere than in Gaza, in the occupied Palestinian territories. But Germany has not only not availed itself of all of the means possible, and specifically as one of the closest allies of Israel to put an end to these probable acts of genocide, but Germany has continued to authorize large-scale delivery of weapons which can be used to commit these acts. Also having to do with genocide, there is one other point. The Article 3 of the 1948 Convention, which you see on the screen, alleges not only the genocide itself, as it is defined in Article 2, but also complicity in genocide is mentioned. And in its judgment of 2007, the court noted and affirmed in very clear terms that there is no doubt that complicity, in the sense of Article 3, paragraph E of the Convention, includes the provision of means to enable or facilitate the commission of the crime. End of quote. Elaborating even further, although complicity as such is not a notion which exists in the current terminology of the law of international responsibility, it is similar to a category found among the customary rules constituting the law of state responsibility, that of the aid or assistance furnished by one state for the commission of a wrongful act by another state. You referred to this under Article 16 of the ILC Articles on the Responsibility of States, which expresses, and you noted it, following the customary rule that follows, and I quote, "A state which aids or assists another state in the commission of an internationally wrongful act by the latter is internationally responsible for doing so if little a, that state does so with knowledge of the circumstances of the internationally wrongful act, and little b, the act would be internationally wrongful if committed by that state," end quote. And you have specified not noting a reason, and I'm quoting here, a reason of establishing a substantial difference between the complicity in genocide in the sense of Article 3, paragraph E of the Convention, and the aid and assistance of a state in committing such a wrongful act by another state in the sense of Article 16 above. As Nicaragua has shown in its request, and also added to by Mr. Mueller, Germany was aware and continues to be fully aware of the risks that the weapons that they are furnishing and are continuing to furnish could be used by Israel in committing a genocide against the Palestinian people. And it is self-evident that the genocide in question would be internationally wrongful if it were committed by Germany itself. It is extremely urgent that Germany finally suspend their aid and assistance that they are supplying to Israel to this end. This aid and assistance are straight from the definition of complicity set out in Article 3 of the Convention. The urgency of ceasing the delivery of weapons, which would allow Israel to continue its deadly enterprise, has also been recalled recently by the Human Rights Council and by the Special Rapporteur on the Occupied Palestinian Territories. And I would like to quote from this latter in English.
Rapporteur urges member states to enforce a prohibition of genocide in accordance with their non-derogable obligations. Israel and those states that have been complicit must be held accountable and deliver reparations commensurate with the destruction, death, and harm inflicted on the Palestinian people. Ms. Albanese called upon all states to, and I quote again, immediately implement an arms embargo on Israel, as it appears to have failed to comply with the binding measures ordered by the ICJ on 26 January 2024. Dans sa résolution
In the resolution from last Friday adopted, despite the negative vote by Germany, the Human Rights Council has also urged all states to continue to provide emergency assistance, including humanitarian relief and development assistance to the Palestinian people to alleviate the financial crisis and the dire socioeconomic and humanitarian situation, particularly in the Gaza Strip. He emphasized the vital role of Unrwa for Palestine refugees in the Near East in providing basic and necessary services for millions of Palestinians in the region, and called upon all states to ensure that the agency receives predictable, sustained, and sufficient funding to fulfill its mandate. Nicaragua invites you, members of the court, to join your voice, clad in its binding force, to those voices of the Special Rapporteur and the Human Rights Council, who, while they do have authority, do not have the binding force that yours does. This reasoning is also transposable mutatis mutandis to the support for other measures which Nicaragua is asking you to indicate. And it is also transposable since the dolus specialis, which is one of the conditions of the existence of genocide, which you have already judged plausible, is presented, obviously, is not considered relevant because of the serious breaches of international humanitarian law and human rights, which Germany has held to be responsible for. This is assuredly the case, when these arms are supplied because they can be used for committing serious breaches of international humanitarian law, as well as war crimes and the crime of apartheid. And Germany could only be fully aware of these risks and at least of their plausibility. These obligations clearly weigh on Germany and impose that Germany not offer assistance to Israel in these actions, which are contrary to international law, but instead to mobilize all of their means, which they have at their disposal and continue to have at their disposal, to ensure the compliance by Israel of humanitarian law. It is even more crucial since Germany has great influence with Israel, thanks to the strength of the political links which unite these two states, links that Germany should avail themselves of at all times. Mr. President, Germany has done everything to repent for the Shoah, and this is to their honor. Germany is shocked that we even dare to accuse it of assisting in genocide and even of not scrupulously respecting international humanitarian law norms, which are also at stake in this case. Just as Israel, which is the Jewish state, and the victim of the horrific Shoah, that Israel is appalled that we could accuse it of genocide. However, nobody owns the trademark of genocide. No state, not Israel, not Germany, can be free of the fundamental rules of international law under the pretext that they can defend themselves or aid the victim of such an attack to defend themselves. You must, members of the court, recall this with the means that are yours, the weapon of law, and this is what Nicaragua is asking of you. Mr. President, before asking you to once again call to the bar the Ambassador Arguello Gomez, the agent and counsel of Nicaragua, I would like to address to you, members of the court, my heartfelt thanks for your attention. I have often had the honor of taking the floor here in this great hall of justice, but I've rarely and perhaps never been so aware of the responsibility which is weighing on all of the actors here, not actors in a play, but actors in a judicial drama, which is playing out in this hall. This responsibility weighs on the counsel of the parties as it does on the court. Thank you.
Je remercie Monsieur Professor Pelé,
Thank you very much, Mr. Pele.
the agent of Nicaragua, His Excellency Mr. Carlos Arguello Gomez. You have the floor, sir.
Mr. President, members of the court has heard from Dr. Mueller the facts which impel Nicaragua to initiate this case and this request for provisional measures. And Professor Pelé has just explained how Germany's conduct in relation to the ongoing situation in Palestine entails its responsibility under international law. That responsibility arises under two broad headings. First, Germany's responsibility for its failure to take the action required by international law to prevent and punish the commission of genocide and of serious breaches of international humanitarian law. And second, Germany's responsibility for its actions or omissions that have facilitated and continue to facilitate the commission of genocide and of serious breaches of international humanitarian law. That is, a responsibility for Germany's omissions and for its own acts. It remains for Nicaragua to address the criteria according to which the court exercises its discretionary power to indicate provisional measures under Article 41 of the statute. The criteria are well established. There must be an admissible claim concerning a legal dispute over which the court has prima facie jurisdiction. As to jurisdiction, Nicaragua relies on the declarations accepting the compulsory jurisdiction of the court made by Nicaragua and Germany, respectively, under Article 36 of the court's statute. As is explained in Nicaragua's application, there are no reservations in either declaration relevant to the present case. Nicaragua's reservation relates to matters before 1901 and Germany's to the deployment of its armed forces abroad in the use of German territory for military purposes. In addition, Article 9 of the Genocide Convention, to which both Nicaragua and Germany are parties, provides jurisdiction over certain aspects of Nicaragua's case. It is evident that these grounds, prima facie, afford a basis on which the jurisdiction of the court might be founded. The legal dispute was described in Nicaragua's letter of 2nd February 2024, in which it specified the breaches of international law for which it considers that Germany is responsible. The breaches relate to obligations under the Genocide Convention, the 1949 Geneva Conventions, and additional protocols, and customary international law. Germany announced its rejection of Nicaragua's claims on 7th February 2024. Nothing more was heard from Germany on the subject on a bilateral level, but Germany continued to reiterate publicly its support for Israel, evidencing the difference of positions with Nicaragua in the subsistence of the dispute. On 1st March 2024, Nicaragua filed this application with the court as the only avenue holding out any hope of swiftly upholding the application of international law. The timescale and bilateral level of intercourse was not lengthy and extensive, and that is as it should be in a case where the allegations concern an ongoing genocide and grave violations of international humanitarian law. It would be a blind retreat into formalism to require round upon round of diplomatic exchanges to reiterate the flat rejection of Nicaragua's claims that Germany had made on 7th February and its reiterated public support of Israel's actions in Palestine. This rejection was again evidenced in Germany's note verbal of 11 March 2024. Mr. President, Nicaragua's claim is plainly admissible. This question has been discussed in Professor Pelé's presentation, but it is relevant to emphasize it in the context of the criteria for ordering provisional measures, which is here under discussion. As a contracting party, Nicaragua has a legal interest in the protection of the rights secured by the Genocide Convention. The point was reaffirmed earlier this year by the court in the context of South Africa's request for provisional measures. It is plain that the same is true in respect of the 1949 Geneva Conventions and additional protocols and of customary rules of international humanitarian law, which they embody. The court itself has said, I quote, that all states parties to the Geneva Convention relative to the protection of civilian persons in time of war, 12 August 49, are under an obligation while respecting the United Nations Charter and international law to ensure compliance by Israel with international humanitarian law as embodied in that convention. I'm citing your advisory opinion on the Wall case. These are obligations erga omnes or erga omnes partes, and each other state or state party has an interest in compliance with them in any given case. The court's jurisprudence refers to 4 other considerations to be taken into account in answering a request for provisional measures. 1, the plausibility of the rights claim. 2, the link between the provisional measures sought and the rights underlying the main merit claim. 3, the risk of irreparable harm. And 4, the urgency of the need for provisional measures. They all go to the basic question whether provisional measures are necessary in order to preserve rights which may subsequently be adjudged to belong to either party in the case. The plausibility of the rights claim and the link with the rights sought required are evident in the present case. As in the South Africa versus Israel case, there is here, and I quote, a correlation between the rights of members of groups protected under the Genocide Convention, the obligations incumbent on state parties thereto, and the right of any state party to seek compliance therewith by another state party, end of quote. And the same is true of rights under the Geneva Conventions and international humanitarian law. The rights of members of groups protected under the conventions and international humanitarian law, here the Palestinians, are self-evident. They include the right to be spared from genocidal attacks and treatment that fails to reach even the basic standards of international humanitarian law. Nicaragua seeks to secure compliance with the obligations that underpin those rights. But in this action against Germany, it is not for compliance with the obligation to refrain from such attacks. Rather, as already stressed by Professor Pelé, the obligations of Germany that are in question are its obligations to take actions to prevent or punish breaches of the Genocide Convention and of international humanitarian law, and to refrain from complicity in or facilitation of such breaches. These obligations have indisputably arisen in this case. The existence of this obligation for states parties to the Genocide Convention and its engagement in respect to the attacks in Gaza has already been determined at least since the order of the court of 26 January 2024. It can scarcely be denied that the same is true in relation to the obligations to prevent and punish breaches of the Geneva Conventions and of international humanitarian law, as Professor Pelé has explained. The Palestinians are being denied the rights to protection and are dying and being injured and having their homeland reduced to rubble because of it. Similarly, Nicaragua is also requesting provisional measures on the basis that Germany is not only failing its duties to prevent and punish these breaches, but that it is complicit in them by aiding and assisting the commission of the breaches. The facts in Gaza and the other parts of the Palestinian occupied territory are notorious. They have been filmed and reported on and broadcast for the past 6 months, in spite of the difficulties and the more than 100 journalists killed. In its last order of 28 March 2024, the court referred to, and I quote, the catastrophic situation in the Gaza Strip and the worsening conditions of life faced by Palestinians in Gaza, in particular the spread of famine and starvation, end of quote. Germany cannot but be aware of these statements by the court. In fact, Germany has announced its intention to intervene in the case lodged by South Africa in favor of Israel. So it is obviously aware of the orders of the court in this case. Mr. President, Germany cannot but be aware that the munitions, the military equipment, and the war weapons it is supplying is being used by Israel in these attacks. It does not matter whether an artillery shell is delivered straight from Germany to an Israeli tank shelling a hospital or university, or whether that artillery shell goes to replenish Israel's stockpile for use at some later date. It doesn't matter whether the planes used in combat and to drop one-ton bombs on the population were made entirely in Germany or just their spare parts and maintenance were supplied. The fact is that the assurance of supplies and replacement for armaments is crucial to Israel's pursuit of the attacks on Gaza. That much is evident from the emergency arrangements made by states such as Germany and the United States, among others, to continue with military supplies to Israel, even during the actual conflict in the face of daily breaches of international humanitarian law. These are the rights that Nicaragua invokes, and their plausibility is beyond question. But there's another aspect. Nicaragua is also seeking here to protect its own distinct rights under international law, which raises a principle of the greatest importance. Those distinct rights are the rights entailed by accession to multilateral conventions in which all parties bear individual responsibility for securing the aims of the convention. Those responsibilities necessarily require each state party to conduct itself in a manner that does not undermine the aims of the convention. Certainly, there are many states and organizations calling for compliance with international humanitarian law in observance of what the court has called elementary considerations of humanity in Gaza. But there are also states pouring gasoline on the fire. There are states that continue to supply or to permit companies within their jurisdiction to supply munitions of war to Israel, knowing that such weapons are being used against Palestinians in violation of international humanitarian law and elementary considerations of humanity, and are thereby actively undermining these rules and principles. Sadly and shamefully, there are also important business interests that are profiting from this ongoing Nakba. The important point is that such undermining is breaking faith with the other states that are committed to securing the basic rights and protections embodied in international humanitarian law. In more strictly legal terms, such conduct breaks the duty of cooperation in the promotion of the aims of international humanitarian law. That duty to cooperate is a general principle of international law with its own chapter in the Declaration on Principles of International Law of 1970. Specifically, it is at the heart of the undertakings in Article 1 of the Genocide Convention and in Common Article 1 of the 1949 Geneva Conventions and the 1977 additional protocols to the Geneva Conventions and the Apartheid Convention and the basic principles of international humanitarian law. It applies to all states, erga omnes or erga omnes partes. The point is that while cooperation may require much in the way of good faith efforts to pursue internationally agreed policies, it must require that insofar as a state is bound by a duty of cooperation with other states, the state must, at a minimum, refrain from actions that undermine the efforts to secure the common goals. The principle might be inferred from the broader principle of good faith. And in relation to cooperation concerning substantive duties set out in treaties, is underpinned by the rules on treaty interpretation. This focus on cooperation recognizes that while Germany happens to be one of the handful of states whose support for Israel is particularly important and a particularly direct contributor to the continuation of Israel's attacks, as a matter of law, it is obliged to cooperate with other states in using its best efforts to bring these breaches to an end. And as a matter of practicality, it will have to do so if its efforts are to be effective. Nicaragua does not at this stage ask the court to make extensive orders regarding the entire range of Germany's legal duties to take positive actions in order to ensure compliance with the Genocide Convention and international humanitarian law. Nicaragua asks only that the court order that Germany refrain from undermining that aim and making the situation in Gaza worse by providing or allowing the provision of munitions of war and other direct support for Israel at this juncture, and by depriving Unrwa, the organization that is uniquely equipped to deliver humanitarian aid in Gaza, of funding and of the ability to continue working in accordance with its mandate. Mr. President, this is the explanation of the provisional measures requested. The first request and order that Germany suspend its aid to Israel, in particular its military assistance, including military equipment, insofar as this aid is used or may be used in the violation of the Genocide Convention, international humanitarian law, or other peremptory norms of general international law. This requires a halt to the execution of any agreements for the supply of material or services that could be used or are being used by Israel for its attacks. In view of the recent news and the possible more massive supply of weapons to Israel, it is necessary to add this note and this point. It is public knowledge that Germany collaborates with the United States in several military programs related to a fabrication of equipment and spare and replacement parts, technical and logistical support, among other aspects. The United States is in the process of approving a plan to sell $18 billion worth of F-15 fighter jets to Israel, a new order for F-35 jets, and an additional $14 billion in military aid, including weapons and technology for our missile defense. If this new deal by the United States involves Germany, Nicaragua wishes to make clear that this collaboration with the United States or any other associate must cease in the current context and should also be considered as part of any measures the court might decide to adopt. Mr. President, the second measure requested requires Germany to use whatever legal or contractual powers and whatever influence it has over Israel to ensure that weapons already delivered by Germany and German entities to Israel are not used to commit or facilitate serious violations of the Genocide Convention or of international humanitarian law. The third request seeks an order that, as part of its duties to prevent violations of the Genocide Convention and international humanitarian law, Germany resume its funding of Unrwa for its activities in Gaza. The crippling of Unrwa appears to be the biggest impediment to a distribution of humanitarian aid to the Palestinians who need it most, part of what the European Union and the United Nations have referred to as the weaponizing of hunger by Israel. The request thus focuses precisely on a step that Germany can take that will have great practical effect in alleviating the suffering and destruction. The submissions do not formally request the court to recall to the parties the obligation of compliance with humanitarian law, as well as the obligation of cooperation to bring to an end all serious breaches of peremptory norms of international law. The reference in the submissions is simply a reminder of existing obligations that do not need to be specially ordered by the court. The link between these measures and the rising issue at the merit stage is obvious. The measures requested are conservatory. They are needed in order to ensure that Germany stops aiding and abetting the complete devastation of Palestine, and that Gaza in particular is not completely devastated before the court hears the merits of this case. For that same reason, the urgency and necessity for the measures is, Nicaragua submits, as obvious as it could possibly be. The killing and the destruction are continuing even as we sit in the Peace Palace of the Great Hall of Justice, at the heart of the only really global institution mandated to uphold the rule of law. Mr. President, members of the court, in considering the request for provisional measures, I will call attention to the importance that the decision of the court be addressed to ordering concrete measures that admit of no rationalizations in their compliance. An order by the court that simply recalls clear pre-existing obligations that should be complied with without any specific order would not be effective. In the course of these pleadings, we have referred on several occasions to the advisory opinion on the construction of a wall. In this opinion, the court considered the legal consequences of the internationally wrongful acts of Israel as regard other states. The situation then involved actions that, in comparison to what is now under consideration, would seem almost trivial. Yet the obligations then also under consideration involve similar peremptory norms of international law that, in the present circumstances, apply even more forcefully and urgently. Mr. President, briefly, in that case, the court reaffirmed the obligation of all states not to recognize the illegal situation created by acts contrary to peremptory norms. Then the actions under consideration were the construction of a wall. In the present case, the destruction of a people. The advisory opinion reaffirmed the obligation not to render aid or assistance in maintaining that illegal situation. It specifically recalled the obligation, I quote, to ensure compliance by Israel with international law as embodied in the Geneva Convention, end of quote. But in dealing with the construction of a wall, the court did not limit itself to refer directly by name to one state, Israel. It also recalled the obligation of all states to ensure that Israel complied with international humanitarian law. An advisory opinion certainly is not a binding decision within the scope of Article 59 of the statute, but it represents a statement by the highest judicial organ of the United Nations on the law in force. States that do not act in accordance with international law as interpreted by the court are not violating a judgment of the court. They are simply violating international law. Mr. President, if the obligation of all states with respect to the actions of Israel in Palestine, as stated in the Wall Advisory Opinion, had been complied with, we would not be here before you today. This is why we consider that the measures ordered by the court should be clear, specific, and of unavoidable compliance. Germany, as all other states of the international community, has been aware, at the very least since the year 2004, when the advisory opinion on the construction of a wall was given, that peremptory norms of international law imposed the obligation not to render aid and assistance to Israel against violations of international humanitarian law as embodied in the Geneva Conventions. As we have pointed out in our application in the course of this pleading, Germany, as all states of the international community, has been aware since at least the 9th or 10th of October that serious violations of international law were being committed by Israel in Palestine, and at least as from the date of the order of the court of 26 January of the possibility that these violations constituted a crime of genocide. And Germany, as of today, ignoring its glaringly obvious obligations, continues providing assistance to Israel. Mr. President, this has got to stop. That is why we have come before you and why Nicaragua makes the following submissions. I will proceed, Mr. President, to read Nicaraguan submissions. Nicaragua respectfully requests the court, as a matter of extreme urgency, pending the court's determination of this case and the merits, and after recalling to the parties the obligation of compliance with humanitarian law, as well as of the obligation of cooperation to bring to an end all serious breaches of peremptory norms of international law, to indicate the following provisional measures with respect to Germany and its participation in the ongoing plausible genocide and serious breaches of international humanitarian law and other peremptory norms of general international law occurring in the Gaza Strip, as well as in other parts of Palestine. Namely, to order that, 1, Germany must immediately suspend its aid to Israel, in particular its military assistance, export, and authorization of export of military equipment and war weapons, insofar as this aid is used or could be used to commit or to facilitate serious violations of the Genocide Convention, international humanitarian law, or other peremptory norms of general international law. 2, Germany must immediately ensure that military equipment, war weapons, and other equipment used for military purposes already delivered by Germany and German entities to Israel are not used to commit or to facilitate serious violations of the Genocide Convention, international humanitarian law, or other peremptory norms of general international law. 3, Germany must resume its support and financing of Unrwa in respect of its operations in Gaza. This is the end of Nicaragua's ambitions. Mr. President, members of the court, this concludes Nicaragua's pleading. Thank you for your kind attention. I would also like to thank the registry and staff and the interpreters for their invaluable assistance. My thanks also to the Nicaraguan team. Thank you.
I thank the agent of Nicaragua, whose statement brings to an end the single round of oral argument of Nicaragua, as well as this morning's sitting. The court will meet again tomorrow, Tuesday, 9 April, at 10 a.m. to hear Germany present its single round of oral argument. The sitting is adjourned.